People often ask generally, what should I do if I come into contact with the police? And my answer always is, it depends on what the situation is. Understanding the criminal justice system and what the police may or may not be able to do is important in understanding how you respond. So how you respond when you're pulled over in a traffic situation may have a lot to do with what was it that you were doing. Were you speeding? And how you respond to the police, understanding what your constitutional rights are, also understanding that police are human beings and the way that you interact with them can have an impact on whether or not you get one ticket, a warning, or several tickets. When it comes to criminal charges, understand what the government can do in terms of an arrest, a report, an indictment, an information. Those are all terms used by people who are in the criminal justice system. Law enforcement can arrest you if they see you commit a crime. They can also make, in certain circumstances, a determination to not charge you. That is their ability to weigh the circumstances and decide whether or not this is something that needs to go past an initial encounter. They can issue you a notice to appear, meaning a requirement that you show up for court at a later date. In certain circumstances, they can write a report and send that report into the state attorney's office for review. That is what's called a sworn complaint. So law enforcement can arrest you if they see you do something. They can also go to a judge and say, we want to get a warrant issued for this person. This is the evidence that we have. That's usually on more serious or complex cases. There are several nuances in the way that a law enforcement officer can bring a case to either court or to a state attorney for review. Certain cases, such as criminal traffic infractions, a law enforcement officer can simply write a citation, and that is what's considered a formal charging document that would require you to show up in court. Other cases usually require a state attorney to make a determination, even if you were arrested, to decide whether or not this is a case that needs to move forward and be prosecuted. One of those commonly is what we call domestic violence. If law enforcement gets called to the scene of a situation and they believe they can determine who was, quote, the primary aggressor in that case, and it is domestic in nature, almost every agency in the state of Florida is going to make an arrest. That arrest does not mean that you are convicted. It doesn't even mean that you've been charged. The next step is for the state attorney's office to review information, speak with the alleged victim, review any witness statements, any 911 calls, any video surveillance, all of the information that is available to them to determine whether or not they're going to charge you. It is always the best advice that if you believe that you are a suspect in any sort of criminal case, or if you've been arrested, to contact an attorney immediately. Also understand that immediately after you are arrested, you have the right to remain silent. You have the right to ask for an attorney. You need to do both of those. Just by saying I'm not going to answer any questions doesn't mean that they will necessarily, you've invoked your right to an attorney because you haven't said that. They can just let you sit for hours, and potentially once you get frustrated, you could start answering questions. The way to end questioning immediately is to say, I'm not answering any questions until I speak with an attorney. There are a couple misconceptions when people usually come to meet with me. One is that they said, well, I was never read my Miranda rights. Miranda rights, as you've seen probably on television, almost all of us are familiar, the right to remain silent, the right to have an attorney. Law enforcement doesn't have to read you your Miranda rights. However, if you have been placed in a custodial situation, or if you've been placed under arrest, if they ask you questions, and they have not read you Miranda, there is going to be an issue as to whether or not those statements can be admitted against you in a trial. But if they see you do something wrong, they've talked to witnesses, they don't have to read you Miranda. They can arrest you and take you to jail because from their perspective, they don't need to hear from you. That may be in your favor because you're not being asked any questions which could end up making your situation far worse. People often ask, and I've even heard law enforcement indicate that, well, if that person would have just talked to me, this wouldn't have gone this way. And that is a very difficult situation to navigate because law enforcement doesn't have to tell you truthfully every piece of information that they have. And in my experience, most of the time, if law enforcement is going to make an arrest, they're not going to change their mind based on what you tell them. They're just going to use whatever you say to try and bolster their case. That's why specifically when you're read Miranda, anything you say can and will be used against you in a court of law. That's what they're trying to do. That is their job. Their job is to try and build a case and to make an arrest if they believe they have probable cause to do so. If you are arrested in Florida, you will be taken in front of a judge within 24 hours. That is what's called a first appearance. At that time, the court is not going to determine whether or not you did or didn't do something, and you're not going to be able to explain to the judge, and the judge is probably going to hopefully stop you from trying to explain what happened, the facts of this case. They're only there to determine whether or not there was probable cause to arrest you, and then to set what they believe is a reasonable bond. That should be based on a number of factors: your contact to the community, the nature and circumstances of the case, and whether or not you're a flight risk. In doing that, the court will set a bond. Certain cases have certain additional requirements, some of which may not allow you to be released. This is what we call pretrial detention. Those are usually more serious or more violent cases. If you are on probation and you are arrested, you are not usually entitled to a bond, and you will be held until you go back in front of the judge that sentenced you. If you are in another county when you're arrested, that can be a real problem because you're not going to be able to get out until you go back to where you were sentenced. If you find yourself in a situation where you're being questioned by law enforcement, or unfortunately you've been placed under arrest, if you are able, reach out and speak to an attorney. If you're not able to, have family or close friends contact an attorney and set up a consultation. My name is John Whittaker. I'm a partner with Avera Smith. We would be honored to sit down and discuss the facts and circumstances of your case and help you.